Hello, and thank you for joining me as I discuss a very important subject: 10 costly mistakes to avoid when planning for a loved one with special needs. These lessons have been learned from dealing with our family office clients and watching these mistakes, how they are executed by well-meaning parents, siblings, and other caregivers. The problems that are created by these mistakes have been very successfully solved by our tax, legal, and financial planners over the years. My hope is that by shedding light on these mistakes, it will help others avoid the same costly mistakes. So, the first costly mistake is doing nothing. That's the most popular estate plan in the United States, is to do nothing. Now, while this is not a good idea for anyone, it is particularly troubling when there's a loved one with special needs involved. If someone does nothing and then dies under the rules set forth in the state's probate code, the state probate code does not consider whether a loved one has special needs. This could cause the wrong person being named to manage your loved one's care, or even cost your loved one access to essential public benefits. Doing nothing is not an option. The next costly mistake is disinheriting the loved one. Many families who have a loved one with special needs rely on supplemental security income, SSI, Medicaid, or other government benefits to provide basic food and shelter. To protect these benefits, we've seen parents that have been advised to disinherit their loved one with special needs. Now, this is never a good idea. This is the person who needs your help the most. If there are no assets to set aside for the loved one, he or she will depend on public benefits, and public benefits rarely provide more than welfare-level care. However, a well-drafted third-party special needs trust provides legal protection for your loved one's inheritance that can be used to supplement that loved one's public benefits. Some people make the mistake of just assuming others will care for their loved one. Some people decide that the best option is not to leave any assets to the loved one, but leave them to someone else with the promise that they will take care of the loved one with special needs. Now, this plan is full of landmines. Even well-intentioned siblings have their own lives and financial concerns and may focus on those concerns rather than the loved one's special needs. Other issues also arise, such as when a caregiver that is left the money divorces, and some of the funds go to an ex-spouse who has no interest whatsoever in protecting the loved one. Whoever is put in charge may die or become incapacitated. Their heirs may not care for your loved one as thoughtfully and completely as you wanted. If the caregiver loses a lawsuit or faces financial difficulties, or has significant creditor problems, that caregiver may resort to using the funds intended for your loved one, or a court may require the caregiver to turn that money over to a creditor. But if you create a third-party special needs trust, you protect everyone. The trust will provide a way to leave clear and legally binding instructions to care for your loved one, and protecting the assets you've set aside for your loved one's care at the same time. When you provide clear instructions and a helpful structure, you lessen the burden on all, and you support a loving relationship between them, which also protects your loved one with special needs. A fourth mistake is using a one-size-fits-all needs trust. Now, while a special needs trust will provide legal protection for your loved one, some special needs trusts are unnecessarily inflexible and generic. Many trusts are off the shelf and not customized to a loved one's needs. The trust may preserve government benefits, but does so by preventing the trustee from making other distributions that could otherwise enhance the quality of the life of the loved one. Many of these bare-bone trusts have a distribution standard that prevents the trustee from making distributions that may reduce or eliminate public benefits. But this could prevent distributions that may be in the best interest of the beneficiary. Some attorneys make special needs trusts irrevocable upon signing. Now, while this is sometimes appropriate, most people prefer a revocable trust to retain their right to improve or change the trust as the years pass. Over time, their loved one's needs are going to evolve, and that could dictate the trust provisions. And just as important, changes in the law can be reflected in a trust. The special needs trust needs to be flexible and personalized to your loved one's needs. A serious mistake is failing to plan for more than public benefits. The main issue with a one-size-fits-all special needs trust is that the only goal is preserving public benefits. While preserving public benefits is important, it should not be the only goal. The special needs trust should be designed to enhance your loved one's quality of life in all aspects. This can include financial planning for the life of the loved one, planning for where the loved one will live, planning for the persons who will provide the care and the advocacy, and developing a lifetime management team, and developing a plan for proper caregiving. Special needs planning is not about the document. It's about making sure your loved one with special needs has the legal protections necessary to fully enhance their quality of life when you're not there to do so. A common mistake is not using a professional who focuses on special needs planning. Too many of these plans fail because the professional who created the plan did not understand the unique needs of a person with disabilities. Sometimes it's a financial planning professional who treats special needs persons' unique financial needs as the same as everybody else. Sometimes it's an estate planning attorney who doesn't understand the specific public benefit rules and creates a plan that fails the legal requirements. Sometimes these lawyers insert a government payback provision into the trust rather than allowing the remainder of the trust to go to other family members upon the death of the loved one. This government payback provisions are only necessary in certain types of special needs trust. An attorney and financial advisor who understand how to plan for a person with special needs can save the family hundreds of thousands of dollars or more. Don't make the mistake of failing to include others in the planning process. A key benefit of creating a special needs trust that is effective immediately is that your extended family and friends can also make gifts or leave inheritances to the trust you create. This will reduce the cost of the family in trying to set up different plans for different situations. Other family members may wish to leave funds for a loved one with disabilities. A letter explaining that you've created a trust that will protect your loved one's benefits, enhance their life, and preserve assets may be very warmly received. This letter should also provide instructions on how to properly name the trust as a beneficiary. A common mistake is choosing the wrong management team. The choice of who is responsible to manage your loved one's assets is probably one of the most challenging aspects of creating a sustainable plan. During your life, you can manage the special needs trust. When you and your spouse can no longer serve as trustees, you must choose who will serve according to the instructions in the trust. One of the most effective teams is having the professional serve as trustee, while family members serve as part of the trust advisory committee or trust protector. This way, the trustee is responsible for keeping apprised of the public benefit rules, managing the day-to-day finances, and providing disbursements, maintaining records, and preparing accounting, while the family makes sure the trustee is doing what that trustee is supposed to do. If the wrong person is put in charge, or if the right person dies and there's no plan for succession, the entire special needs plan will fall apart. Don't make the mistake of failing to protect the loved one from predators. Now, all too often, loved ones with special needs fall victim to predators. This could be a financial scam where someone takes over the assets, or a trick that deprives them of much-needed care. Predators are particularly attracted to vulnerable beneficiaries, such as the young and those with limited self-protective capacities. With a trust, you limit access to the information about your loved one's money. It further protects them from the loved one that cannot go where the assets are lying. So finally, don't make the mistake of failing to properly fund and maintain the plan. A special needs plan must have assets to make the plan work. Now, this is an excellent time to bring together your financial planner and attorney to assist in creating a lifetime plan. The financial advisor can create sample future scenarios that show how much is needed to fund the plan and then present different ways to accomplish that goal. Sometimes it's adding a life insurance policy and naming the trust as beneficiary, or it may be using existing assets. The attorney can then make sure that the plan created will meet the needs of the loved one throughout their life. Finally, the plan should be reviewed every 3 to 5 years to make sure it continues to meet the loved one's needs. By doing so, you have created an effective special needs plan that will last a lifetime. So I hope you can see from these mistakes that it takes a coordinated effort between you, your family, your financial planners, attorneys, tax professionals to really develop a plan and a solution for caring for a loved one with special needs, especially when we're talking about years and years of care. So I hope this information has been helpful, and there are some resource materials here that you can download and save. In the related content section, there's a document entitled 10 Costly Mistakes to Avoid When Planning for a Loved One with Special Needs. It's a document that contains the information that I've discussed here. There's also a quick quiz to see if you and your family could benefit from working with a family office. In the recommended content section, there's a document to see if American Wealth Strategist is that family office. But everything begins with a conversation. There is a link to my calendar. Pick a time that works for you, and let's have an initial discussion about your situation, your loved one, and see if working with a family office with legal and financial experts to assist you would be a good fit for you and your family. And I want to thank you for watching, and I look forward to having a conversation with you soon. Thank you.